Now we'll be continuing with the interlocutory application notice of objection for order to strike. Next date of hearing at this point of time was the 27th of February 2017. I will be talking briefly about the process of that you go through as far as lodging complaints. In this case, it's with the Ministry of Health. So we're continuing with this application, but first of all, I will be talking about the process briefly, because there's a process that you've got to go through before you actually take your case to the civil courts. So you've got to go through the proper channels as far as through the complaints process. Then you've got to take it through to the Ombudsman. So you've got to have all that evidence you've done that, and if you weren't satisfied as the complainant or the plaintiff that it wasn't resolved to your satisfaction or there was no resolution, then you take it through to the civil jurisdiction. So I'm talking about the process in the courts in my country, which still exists today. So first you've got to go through all the proper channels as far as your complaints. Now, what I have found with this new system, which is different from the old system, they've divided, they've separated different entities for different agencies, which means you need to find out the right entity or the right agency that that is responsible for anything in regards to fiduciary breaches and complaints, because that's where you lodge the complaints to. But my case is going back to 2017, but these are the things that I have found leading up to my court case, which I think in most cases now in my country, a lot of companies have all split into different entities. So there does make a difference, but you need to find out the correct ones when you're lodging a complaint. And then you just go through that proper process. If you don't get to a satisfactory outcome, then you can take it as far as the legislation was concerned in my back in this 2017 it was. The next step is you've got to go through the Ombudsman system. So if you go through the Ombudsman system and you still don't get satisfactory, then you can actually lodge a civil complaint or notice of proceeding, a civil case in the civil jurisdiction. So I've gone through all that process, and I'm just briefly going to go over it because I know that hasn't changed. So in this case, I'm dealing with the mental health services for the Ministry of Health. So, but in saying that, overall, Ministry of Health, according to the legislation at this point in time, I'm going back to the year 2017, Ministry of Health actually covers, because they're all medical practitioners, they all fall in one umbrella. In this case, I had lodged my application as Ministry of Health. That's after going through the Ombudsman process. Now, you got to also have evidence that you've gone through that process, which is what I've done here, and I've put all that information in this interlocutory application as proof. So I can actually prove to the courts that I've gone through the proper channels, haven't come to a satisfactory conclusion or outcome. So now I'm pursuing the civil jurisdiction as far as dealing with my complaint. All right, so as you can see, I've got here number 1, Ombudsman, and then I've got in here affidavit of Minicrichton dated 9th of February 2017, correspondence with District Inspector for Mental Health. Now, I've actually removed the names of all the mental health district inspectors, but they are actually named on the actual documentation. So I actually named all of them on this over here where you see it's blank. Then I've got A, bracket A, Exhibit 1, page 2, affidavit of MC, dated 9th of February 2017, email dated 17/6/16. I've also got here evidence that I had sent my complaints to the info@ombudsman.parliament New Zealand, page 2. And I've attached all these emails as exhibits. But what I've done is I've actually just written out a few quotations from the email that is relevant as to prove my case to the judge. And I'll read it quickly. I have made official complaints to the Ministry of Health for District Inspector. On the 31st of May 2016, I officially lodged a complaint and sent my complaint with the evidence to, and blank, it was a district, there's a name there, but I've removed it, who said he will give my complaint to the appropriate people within my district. 16 days later, no one has been responding to my emails to confirm that they are investigating my complaints or not. Yesterday, I received a response from, and they had the name of the person there quoted, I am assuming the dealing with your matter has now responded. Please let me know if that has not occurred and I will follow up. I would like to know if I am following the correct process. I got my information from the internet. The following people I have been correspondence with are as follows. So I just had all their names in there, and so that's what I've just taken out a few quotations, but I actually submitted the emails as exhibits, as official evidence that I, proof that I've gone through the proper channels as far as trying to get legal or some kind of satisfactory outcome for what had happened in my case. However, nothing came out of it. Nothing was resolved. Just giving you a fair idea. Okay, what I've also found that they put deadlines, or they have time frames for a lot of things. Like you've got to do some things at certain time frame, and you've got to meet that time frame, which is what I have found. So here's an example right here. Page 2, affidavit MC dated 9th of February 2017, email dated Wednesday, July 13, 2016, Minocration to info ombudsman parliament.new Zealand. Thank you for your response, but I have taken further actions. The appropriate parties will be notified accordingly. I am, however, very disappointed at the length of time that this has taken, and my complaint not taken seriously. The Ombudsman responded to my complaints on the 17th of June and advised me that they will respond to my complaints within 10 days. I have had no response from 5 district inspector in regards to my complaints being investigated, but rather they have ignored them. So here I've just wrote down that their response to me, and they've written, Dear Miss Crichton, thank you for your correspondence received on the 17th of June 2016 about the Ministry of Health. Your complaint has been allocated reference number 431643. We will contact you once your complaint has been assessed, and you can contact us by calling this number. However, nothing happened. Absolutely nothing happened. Sent emails, phone calls, nothing. You couldn't go any further. By the time they tried to try and resolve my issue or ask me about my complaint, I'd already made a decision, because I wasn't going to waste any time, because they've already caused me a lot of stress just even putting the complaints together, and then trying to get things resolved properly through the proper channels, and then the rejection or the prolong of everything just being totally ignored is very stressful. So I decided I wasn't going to waste any more time and put it through the civil courts. But before I carry on to the cause of action for the Ministry of Health, I've just read this bit here where I've sent, I received an email from the MSCs, from one of the district inspector, and they said, my role as a district inspector is to ensure that there are no breaches of service by users' rights. As I understand, the situation and application was made for assessment under the mental health when you were admitted to Waitara unit on 4th of February 2016 and lodged a Section 16 review. There was heard by Judge McHardy on the 9th of February 2016, and you were released of the Act. So that was the actual date of when I was released from the hospital that I was in at that time. So that was the date of the actual court hearing, and that's the judge that heard the hearing that I'd already mentioned. Anyway, continuing, in terms of the complaint process, I would advise that you contact the Waitara manager, and his name here, who can respond to any concerns you had whilst at the unit. The events leading up to your admission would be best referred to your lawyers who represented you at the employment hearing and the review hearing. Enclosed is my official complaint in regards to the misuse of the Mental Health Compulsory Assessment and Treatment Act 1992. I do have further substantial evidence that I can forward to you if you require. I am not sure of your full process and have got my information off the internet. I do have further evidence to support my complaint. I will forward that to you as soon as possible. So what I'd actually done, what I'd sent to the district inspectors at this point in time, I had drafted up a timeline summary of events dated 31st of May 2016, and I submitted it as an exhibit in the affidavit 4th of July 2016. What I'd actually done in this documentations of timeline summary of events, I bullet point all the incidents, or the everything that happened and occurred during, before and leading up to and afterwards. So that's what I've done, and that's what's the information on the actual timeline summary. And they all got it. They also had a lawyer that was involved in this at this point of time when I was lodging my complaints. So I think in total there would have been roughly about 5 district inspectors and a lawyer for the Ministry of Health. So what I'm basically just putting in here in evidence in my interlocutory application, I just prove to the judge that I've gone through the process, proper channels, and nothing's been resolved. And so I took it to the courts, which we are allowed to do, even if you're representing yourself. So at this stage, I'm still representing myself in my case. I also... so as you can see in this interlocutory application, I won't read it because it's quite long and lengthy, but you can see that there was definite correspondence with the Ombudsman and the Ministry of Health district inspectors. So they were all aware of it.